Yeah, thank you, Naveen, for the opportunity to speak on the topic of patents. We had a uh, discussion last year on the topic of fundamentals of IP, which was more towards the basics of IP, where we covered different types of intellectual property, which included patents, trademarks, copyright, geographical indications, and trade secrets. This session is more focused towards patents and the patent processes that are there in India and how to go about filing in worldwide locations. So we'll begin our discussion with the basics of patents, which are the nuts and bolts. So patent is a type of intellectual property that protects an idea. So your idea can be in the form of a technical solution to a problem, and patent provides an exclusive monopoly to this technical solution for the problem. The second point is whoever files first for a patent gets to secure the rights first. So this is very important because many people think that they can wait forever if they are working on some kind of technology or some kind of solution, and once they have sufficient cash or they have funding, they can file patents. But what generally happens is once you are out there in the market, once you're out there uh, where you have made a public disclosure, the chances of you losing the rights are high, because whoever files first for the patent will secure the rights. And this is true for all locations across the world. So there are basically two types of patents: industrial design and utility. We'll be going into more details of what these are and what kind of protection they offer. So patent rights are typically jurisdictional, which means they are territorial rights. So territorial rights are nothing but limited to a specific geography. So if you file for a patent in a specific country, you will get protection in that specific country. So as we move ahead into the discussion, I'll also be covering that there is a myth that goes around with respect to a global patent. There's nothing called as a global patent. Patents are generally jurisdictional rights and they are restricted to a specific territory. And your monopoly to the technical solution comes with a certain validity or term of the patent. So typically, the validity begins at once you file the patent application, and for industrial design, it is 15 years from the date of filing the application. And for a utility patent, it is 20 years from the date of filing the application. So with these basics, let's begin our discussion on what an industrial design is and what kind of protection the industrial design offers. So industrial design primarily protects the non-functional aspects of a technical solution. So let's say you have invented a solution where the functional aspects are pretty well known, but you have designed the product or you have designed the system. And when I say design, it only restricts or is conferred to the ornamental or aesthetic aspect of it. So when I say ornamental or aesthetic aspect, it is restricted to the look and feel. So industrial designs typically protect shapes, colors, patterns, or combinations of that. So to give you a few examples of the industrial design, so you can protect the shape of a bottle and the cap through an industrial design. Likewise, you can protect the thread pattern on a tire through an industrial design. Likewise, you can protect the shape of a chair, a basket, or a vacuum cleaner. So these are a few examples that are picked up from granted patent applications, which are from which are also referred to as design patents. So it is referred to as design patents in other jurisdictions and referred to as an industrial design in India. So Industrial design or design patent do not protect the design of a circuit or a system. So a lot of people think that, if they have designed a system, we can protect it through a industrial design or a design patent. This is not true. Like I explained with examples, industrial design protects only the look and feel aspects of an invention. So the functional aspects are not protected through an industrial design. Functional aspects are generally protected through a utility patent. So we'll be talking about utility patent as we move ahead into the discussion. So one other point that I would like to cover with respect to industrial designs is you can file a single design application or an industrial design application through the Hague International Design System, which is administered or managed by WIPO. WIPO is the World Intellectual Property Organization that facilitates or provides a platform where an inventor can file a single industrial design application and seek protection in worldwide locations. So at the time of filing the application, the inventor is provided with an option to choose the countries in which he or she needs protection, and the inventor is expected to pay the respective search and examination fees and the patent office fees in which they intend to register or get their industrial design examined and registered. So through the Hague International Design System, you can make a single application, which is referred to as an international application, and choose the countries in which you want to seek protection. So the next type of patent that we would be covering would be a utility patent. So utility patent typically provides protection to the functional or operational aspects of a technical solution. So utility patents are again jurisdictional in nature, which means that if you file for a patent in India, you will get protection only in India. And likewise, if you file the patent application elsewhere in other countries, you will get protection in those countries. So typical validity or term of a utility patent is 20 years from the date of filing the patent application. And it has to be, once it is granted, so the patent application goes through an examination process, and on merits it gets granted. And once it is granted, you will have to pay a renewal fee or a maintenance fee every year for you to hold the rights of the patent. So continuing our discussions on the utility patents, so there are two types of utility patent applications that one can file. One is referred to as a provisional patent application, and other is referred to as a non-provisional patent application in the US and Europe, and a complete application in India. So first, let's discuss briefly about what a provisional patent application is. So provisional patent application is never published, it is never examined, and it never matures into a granted patent. So you may ask me the question now, what is the use of filing the provisional patent? And your question is quite valid. So provisional patent is generally advised to be filed when the crux of your idea or technical solution is ready, and you are experimenting with certain features, certain functionalities, and need some time for it. And that some time is 1 year. So once you file a provisional patent application, it is valid only for 12 months or 1 year from date of filing. So let me explain that with a simple example. Now, let's say we filed a provisional patent application today, which is January 9th, 2020. So your provisional patent application would expire on January 10th, 2022. So it would be valid till January 9th, 2022, and the next day itself, the provisional patent would expire. The provisional patent acts as a placeholder, and like I said, if the crux of the solution is ready and you are looking to experiment with certain features, certain functionalities, and need time for it, let's say 3 or 6 months or 8 months or so, you can file a provisional patent application and secure a filing date. Now, what does secure a filing date means? In the basics, we discussed that whoever files for a patent application first will be able to secure the rights. So provisional patent application acts like a placeholder, or it blocks your date of filing. So you get a priority date. So you can, and you should follow up a provisional patent application by a non-provisional patent application or a complete patent application on or before the expiry of the 12th month. So once you follow up and file a non-provisional patent application or a complete application within 12 months from the date of filing of provisional patent application, you can take priority to the provisional patent application. So what does that mean? So let me explain that again with an example. So we filed the provisional patent application today, which is January 9th, 2021. And let's say we filed the non-provisional or the complete application on December 30th, 2021. So once we file the complete, we can take priority to the provisional. Taking priority to the provisional would mean that you are filing the complete application, or it would be as good as filing the complete application today itself. So that is the advantage that you get of filing a provisional patent application. So only a non-provisional or a complete patent application goes through a examination process and gets issued into a patent. So we discussed briefly about the non-existence of something called as a global patent, because I keep getting this query all the time in my practice. Uh, People come and ask saying that, I want global protection, I want to file a global patent. And when I tell them that something like this does not exist, they say that, we have consulted somebody and they say it exists and it can be done. So like I said before, patent are territorial rights and global patent is not defined, so it does not exist. So, but what you can do is, if you want to file in one or more countries outside India, there are international treaties. The first one is referred to as a Paris Convention. The second one is referred to as a Patent Cooperation Treaty or a PCT. So PCT application is again administered and managed by WIPO, which is the World Intellectual Property Organization. And it provides a mechanism or a system where you can file a single international application and choose the countries in which you need protection. So as we move ahead into the presentation, I will discuss more about the advantage of Paris Convention and PCT and the disadvantages as well. So like I said, it must be filed. The patent application must be filed in every country in which you need protection. So moving ahead, let's discuss briefly about the patent process in India. So typical process is you make an application for patent. So the patent application is published in 18 months from the date of priority. So from the date of first filing your patent application, which means that if you have filed a provisional patent application, so at the expiry of 18th month from the provisional patent application date of filing, if you have filed a complete application, then your complete application would be published. So as we discussed, provisional patent application is never published, never examined. Only if you follow it up with a complete application or a non-provisional patent application, it would be published at the expiry of 18th month from the date of first filing the patent application. So once you file the patent application and it is published, you have to file what is known as a request for examination. So only once you file a request for examination, your patent application will enter the examination queue. So please don't be under the impression that once you filed it, it is done. No, there is a next step where a request for examination has to be filed. In India, there is a provision that you can file the request for examination within 48 months from the priority date. So which means that uh, from the first filing of the patent application, you have 48 months on or before you can file the request for examination. But in my practice, I would generally recommend not to wait so long, because 48 months is 4 years. And the purpose of filing the patent application is defeated if you are going to wait for 3 or 4 years just to file the examination. Because once you file the examination process starts, and it typically takes anywhere between 2 to 5 years after you file the request for examination for the entire process to get completed and the patent to be granted. So my suggestion is, by paying extra amount, you can request for an early publication. You can file the patent application, request for an early publication, and file the request for examination immediately so that your patent application enters the queue. So once you file the request for examination, there is a formal and substantive examination of your patent application by the patent office, and they will issue a examination report. So it's referred to as a first examination report, which includes um, a bunch of objections and rejections by the patent office why your application is not patentable. So an agent or the inventor is typically required to respond to this. So applicants require, so there is a box which says applicants respond to the examination. So once you file the response, it's again examined, and if the application is found in the order of grant by the controller, it is allowed. If not, then it is again rejected. So what happens once it is rejected? You can go for a hearing, and even in hearing, if it is not it does not yield a positive result, or if your patent application is generally not allowed, then you can appeal it. So there is an appellate board in India where you can appeal, and once you appeal, so the board will take take a look at your patent application, and the examiner stand as to why it was not allowed, and then they will examine or analyze your application in light of the rules, laws, and acts, and either allow it or reject it. So once it's allowed, it will get granted, the patent would be granted. If not, then the patent would be refused. So post publication and post grant, there are two oppositions that can be initiated by a third party. So once your patent application is published, there is something known as a pre-grant opposition. So before the patent is actually granted, so any third party or a competitor can challenge the validity of the patent. So what is a pre-grant opposition or a post-grant opposition is? Any third party or any party who is interested, or it can be your competitor or anyone who is interested in your business or in your patent, will challenge the validity of the patent. So there is a pre-grant process and a post-grant process that one has to go through. So the validity can be challenged in such a way that there will be a search done by the third party or your competitor, and they will provide a search results and say why your patent is not valid. So drafting the patent application plays a very significant role to avoid this pre-grant and post-grant oppositions. So the quality of the application plays a significant role here, and the validity, whether the patent remains valid after it is challenged, will depend on how well the patent application is drafted. So this is the patent. So moving ahead, we'll briefly discuss about the patent process for foreign filing. So we did discuss about the two international treaties, which is the Paris Convention and the PCT, which is or the Patent Cooperation Treaty. So Patent Cooperation Treaty is again administered and managed by WIPO, which is the World Intellectual Property Organization. So we'll first discuss about PCT and then we'll go to Paris Convention. So you are supposed to file in a foreign country on or before the expiry of the 12-month date. So we did discuss about provisional patent, right? So the provisional patent would not be examined. It has to be followed up with a complete or a non-provisional application. Likewise, you should have clarity on filing the foreign patents as well. So if you're looking to file in the US or any other country, you have to file it within 12 months of first filing in India. So as you can see the timelines, first file a local application, that is, we'll look at the PCT bar first. So first file the local application, which is at the 0th month. So you have 12 months before which you have to file a PCT application, taking the priority to the locally filed application. This has to be done within 12 months. If you miss the 12-month date, you cannot file it. So please be clear that if somebody is telling you that it can be filed after 12 months of first filing, then they are taking you for a ride. So it's clearly, clearly defined process. The international processes are clearly defined and documented, and you have a hard stop or a deadline of 12 months before which you can file in the foreign country. If you do not file within 12 months, you will lose the priority date. Let's say if you've forgotten or you failed to file within 12 months of your first filing, even if you file the patent application later on in any foreign country, you can still go ahead and file it, but you will lose your priority date, and the purpose of filing the patent application would be defeated. In certain instances, your own patent application that you have filed in India may act as a prior art reference to your own foreign filing patent application. So to avoid that scenario, it is recommended that you file within 12 months. So continuing our discussion on PCT, so you file within 12 months, and between 12 months and the 30th month, the application is in international phase. So there is an international search and opinion search that is conducted by the WIPO, and they will give you a search report with a written opinion on patentability, and there is a publication that happens at 18th month. So between 22 and 30 months, there are 4 optional steps where you can request for supplementary international search. You can file a demand for international preliminary examination, or you can request for a supplementary international search report or international preliminary report on patentability. So please be informed that all these steps are charged. So if you go for any of these optional steps, there will be a charge applicable, and depending on the number of countries in which you have filed, the charges may vary. So at the expiry of 29th month, at 30th month, it enters into the national phase. So what does that mean? So if you filed a PCT application within 12 months and you have chosen, let's say, US and Canada, so the first 30 months, your application will be in the international phase, and only at the expiry of 29th month and beginning of 30th month, your application will enter into the national phase in the US and Canada. So predominantly you are actually waiting all the time for 30 months from the date of filing, which is close to 2.5 years. close to 3 years, you can say. And the actual examination process in the national phase does not start till the beginning of 30th month. So how to avoid that? The best route is to go through the Paris Convention. So Paris Convention allows you to file the patent application within 12 months from the date of first filing. So in certain countries, you can take the advantage of going for an expedited filing, expedited examination process. So this expedited examination process is in India also, as well as the US, where you will have to pay an additional fee, and a typical timeline for expedited examination. Once you file it, the patent application is examined on priority, and it would be granted anywhere between 1 to 3 years. If you go through the normal examination track, it would take anywhere between 3 and 5 years from the date of filing. So moving ahead, we briefly discuss about what is patentable. So your idea or technical solution should broadly fall into the category of a product, a process, composition of matter, an article of manufacture, or improvements of any of these. So the basic criteria is that your idea or technical solution should fall into any one of these categories. Apart from this, there are certain rules or acts or laws that are defined by the respective patent offices, which based on which your patent application would be examined. What are they? First is novelty or newness. So your idea or technical solution should be predominantly new, fairly unknown. Second is it should have an inventive step. It is referred to as an inventive step in India, a technical advancement or a technical effect in Europe, and non-obviousness in US. So let's say your idea or technical solution is improvement of, let's say, a product or a process or a composition of matter or article of manufacture. Then there should be significant technical advancement or technical effect that should be visible. It's referred to as non-obviousness. And the third criteria is the utility or the use. So whatever problem you're trying to solve, whatever you're trying to protect through patent should have a utility or use. So when these three criteria are met, the patent application would be granted on merits. So examples of what are patentable. So I'll just briefly talk about each type. Product is something that is composed of moving parts such as machines or computers. Processes are sequence of steps of doing something. Articles of manufacture, again, mouse pad or shoe, hammer, saw. These are all examples of articles of manufacture. Compositions of matter include pharmaceuticals or ingredients. So product, I think most of you are already familiar. I need not give any specific example. Processes, sequence of steps of doing something. This is something that I would like to briefly touch on. So with an example, I can explain that, if you go to amazon.in or amazon.com and look for a specific product, and when you search for a specific product, there are a bunch of listings, and then you select a specific product and add it to cart and begin the transaction, or you begin the process of buying it. So once you log in, you have the option of selecting the shipping address and then selecting your payment method and making the payment and completing the transaction. So these are nothing but sequence of steps of doing something. So if you are sequentially doing something, in this case, you're trying to buy a product and you're completing a transaction by making a payment. This can be patented if it meets the criteria of novelty and or inventive step, which is also having a technical effect or a technical advancement and has a utility. Utility aspect is covered, which means that here there is a transaction. If it meets the criteria of novelty and or inventive step, which is a technical effect or technical advancement, or non-obviousness, then your patent application would be examined on merits and would get granted. By the way, if you go to amazon.com, they have already got a patent on this. So if you look at amazon.com, there is a button called one click, which does all the steps that I mentioned. So once you add the product to the cart and click on one click, it completes the transaction in a click of a button. So they have implemented the sequence of steps of choosing the address, choosing the payment method, and completing the transaction by one click. And Amazon did this back in the 90s when they just started their business, which is why they were able to patent it. Moving on, we'll talk about what is not patentable. Laws of nature and abstract ideas. So simple laws of nature, like electromagnetic radiation, law of gravity is equal to mc square. So if your invention is based on that or using it, it is not patentable. Abstract ideas examples would be um, rules of a game or rules of a transaction. So if two people are doing some kind of transaction or they're playing some kind of a game, they can formulate their own rules or they can formulate their own ways to do the transaction or play the game. So this is something abstract and you cannot patent that. So second is something that is publicly known worldwide. So I get queries again around this very clause. So this is again defined in the uh, Patent Act. So this is not something that I've made up on my own, but these are defined in the Act. So anything that is publicly known worldwide, anywhere, you cannot get a patent for that. Let's say you've seen a product elsewhere, like say in the US or in the Europe, and it doesn't exist in India, and there may or may not be a patent around it. But if you try to bring that product in India or manufacture that product in India or try to patent that product in India, you cannot do that because it is publicly known. So third one, mere presentation of information. So this is very common nowadays. You get a lot of software applications or mobile applications which are doing nothing but aggregating information. So you're just aggregating or collecting information from different sources. You're designing a UI and presenting that information to the end user. So this is again not patentable. I know that many people are trying to patent apps, mobile apps. Mobile apps again per se are not patentable. So we'll talk about this as we move ahead about what is not patentable uh, in the subsequent slide. So mobile app, the functional aspects of the app may be patentable, but if you're merely aggregating information or presenting information to an end user, you will not get a patent for that. Topography of integrated circuits. Examples is the layout of semiconductor chips, where you have a bunch of ICs, resistors, capacitors. They are laid out in a certain way. So the topography cannot be patented. A mere arrangement or a rearrangement of or duplication of known devices, each functioning independently of one another in a known way. So this is a typical example of today's innovations. So most of the innovations are centered around these clauses. So most of the innovations would fall under the purview of this clause. So people are trying to see or integrate different kinds of solutions uh, to solve a problem. So these solutions may be new in a certain area, definitely, but if the solution is already known, right, in some other area, for example, a camera. So let me explain this clause with a simple example. So we all know that camera sensors, the number of camera sensors that you use on a device will improve the resolution, no doubt about it. So earlier, 10 years back, used to have maybe no one lens of camera, and today in the market there are 6 or 8 lenses on one mobile phone. So each lens is designed to do a specific function or a specific activity or a specific operation, just by integrating that into the device doesn't qualify it to become a patent, because the functioning of the sensor, image sensor, is already known. We know that the lens is designed to capture a wide angle or a zoom or a macro mode, and all that you're doing is just integrating things. So if you're just integrating things, that improvement is not patentable. A way of doing a business. So this falls under the purview of business methods. So again, I get a lot of queries here. Let's say you've designed a platform like Amazon, where Amazon is selling products, and you have designed a platform for selling services. So you cannot actually patent that, because all that you're doing is trying to sell services on a platform. The way you do a business, the way you sell a product, or the way you sell a service is again not patentable. One another example is uh, giving insurance to students or job seekers. So this is something that does not exist, right? Now, if you come up with this idea saying that, I'm trying to provide insurance to students such that I can provide them some kind of money or some kind of financial support till they get a job. Likewise, with the job seekers, right? You're taking some kind of money from them, let's say 50,000, and you're paying them 5,000 every month for the next 8 months to support them, saying that while you're unemployed, I'm providing you this. So this is the insurance that we provide. So this is nothing but the way of doing a business. So this purely falls under the purview of a business method, and this is not patentable. So algorithms and computer programs are not patentable. So again, a lot of queries. Most of the startups in the technology domain do develop solutions or solve a technical problem which are centered around algorithms, or solve it using a computer program. Now, the way it is worded and structured in the Patent Act is algorithms per se and computer programs per se are not patentable. Per se is a Latin phrase which means that by itself or in itself, they are not patentable. So the algorithm in itself, without a structure, without a utility, without a technical effect or a technical advancement, is not patentable. A computer program in itself, without a proper structure, without a functional aspect, without having a technical advancement or technical effect, is again not patentable. So it totally depends on the skill of the person who will draft the patent application such that this clause is not invoked. So if the application is drafted in a certain way such that it does not invoke this clause, then you can get the patent granted. Process of treating humans and animals, this is again in India, you cannot patent this. So if you have a new way of treating a human being or an animal, it's again not patentable. So we learned about what is patentable and what is not, and now we will learn about what cannot get you a patent granted. So again, your solution is trying to solve a problem, a global problem, which can be a social cause. So unless it meets the criteria that is defined by the patent office, which is novelty and or having an inventive step, which means it has a technical effect or a technical advancement, or is non-obvious and has a utility, you cannot get the patent. So you cannot just say that, this problem that I'm trying to solve is going to affect 1 billion lives. So I will buy it, but the patent office will not buy it, because they are bound to examine your patent application by a bunch of rules, laws, and acts defined. So, so if somebody is promising you saying that social cause is patentable, then like I said again, please enjoy the ride till it exists. Reinvented wheel, something cheaper. So I think COVID is a perfect example for this. We have seen so many uh, people file patent application for masks, ventilators, PPE kits. These are something that have been existent for more than 10, 20, 30 years. So I would suggest just wait till you get an examination report. If you've already filed a complete application for it, just wait for the examination report and you'll know what the reality is. So if you invented something that is cheaper by procuring local components, you cannot get a patent for that. So please do not try to, my sincere advice is, please do not file a patent for something that is cheaper, because you'll never get a patent for that. If something exists out there and you're trying to just redesign it, and with by procuring local components and reducing the manufacturing cost, that will not get you a patent. Human emotions and effort. This is something that I get very often. People say, inventors say that I've not slept for days, I've not slept for months. I will buy it. I can empathize with it, but the patent office will not, because, like I said, your patent application would be examined against the laws, rules, and acts. So when the patent application was filed, auspicious day, again, this is not going to get you a patent granted unless it meets the criteria of novelty and or inventive step, which is again technical effect or technical advancement, non-obviousness, and has a utility. Just a new utility or new use. So this is very common. Again, like I said, most of the innovations are centered around this. You just look at a new use or a new utility and try to patent that. You cannot get a patent just based on the utility. If you do not meet the criteria of novelty and or the inventive step, you cannot get the patent granted. Who drafted and filed it? Again, people come and tell me that, uh, a friend of mine, he grew up with me, he has filed a patent, or, some celebrity helped me to file the patent. No, that is not going to help you unless the patent application meets the criteria defined by the Patent Act's rules and laws. Your patent would not be granted. So moving on, we'll briefly discuss about a few myths. So ideas cannot be patented, and working prototype or proof of concept is needed. So this is not true. So as long as your ideas can be tangibly manifested, you can go ahead and file a patent application. So what does that mean? Let's say you have a technical solution or an idea that is solving a problem, and you have an input to your idea or your solution, and it is producing an output, and the output is tangible and has a utility that is sufficient for us to file the patent application. But the criteria is you should have clarity on how the problem is being solved. Very simple example to illustrate this concept. Let's say you have an electronic circuit with a bunch of components and a sensor as your technical solution, and the sensor is sensing some kind of input. Your technical solution is processing data, transforming data, or doing some kind of crunching on the data, and then it's producing a output which is tangible and which can be consumed and has a utility. That is sufficient for us for filing the patent application. We don't actually need the working prototype or proof of concept. Second is every innovation is patentable. This is again not true. To illustrate this, let me give you again a very simple example. If you go back in time, 2007 was when iPhone was launched. So when iPhone was launched, it was termed as the most innovation product. So why was it termed so? So when iPhone was released, before iPhone was released, there was a phone in the market. There was a music player, which was an iPod, and there was a web browser. So what Apple did is it integrated these three solutions into a single product, and an iPhone was born. So innovations are generally combinations of two or more solutions. It can be existing solutions. So it can be one or more existing solution, and one can be novel or new. So if that novel or new solution, let's say your innovation is a combination of three solutions, right? Three different solutions from three different areas. So if at least one of your solution meets the criteria defined by the patent office, which is novelty and or has an inventive step, which is technical effect or technical advancement, and has a utility, it's good enough for you to get a patent. But if it does not, if none of the solutions meet any of the criteria, then you cannot get a patent. So it cannot be a mix, make a combination. So your one solution should uniquely meet these three criteria. It cannot be like, one solution is meeting one criteria of novelty, second is meeting of inventive step, and third is meeting of utility. It cannot be so. My advice is try to have one solution, uh, no, even if it is a combination, try to have one solution which will meet all these three criteria, which will simplify the process of examination, and your chances of getting the patent granted would increase. Third one we have already discussed. Anything that is known publicly worldwide, you cannot get a patent for that. So be it a patent or a product anywhere in the world, if it can be publicly accessed, electronically accessed, or can be Googled, or if it is indexed on the internet and can be searched for, you cannot get a patent for that. Abstract is sufficient. A lot of times I have people coming with abstract and showing me, the abstract and asking whether this is patentable. No. In my opinion, please do not go by someone who is promising you uh, a grant of a patent just based on the abstract, because we already discussed all this while that the application would be examined on merits, and it has to meet the criteria of novelty and or inventive step, which is the technical advancement or technical effect, and the utility. All these three criteria cannot be captured in an abstract. If these could be captured in an abstract, then there was no need for us to file the patent application. We could have just filed the abstract and got the patent granted. So that should get you thinking. Please uh, ensure that somebody is promising you based on abstract, then please don't go ahead. Always try to seek a second opinion or seek help of an expert. So the fifth criteria is you can file an incomplete application and try to file something later on. So we discussed this. If you are at that stage, please file a provisional, and once you have clarity, once you've completed solving the problem, only then go ahead and try to file the complete application. Try to do it within 12 months, otherwise you will lose the priority date. Patent application is something that you cannot edit or resubmit once it is filed. So you cannot add any new content to the patent application once it is filed. If you add any new content at any stage during the examination before the grant, uh, the priority date will change, and again the examination process would be reinitiated. So please do not try to file something incomplete and then try to back it up or file the completed solution later on. Try to file a complete solution. Try to buy the time by filing a provisional, and try to file a complete application within 12 months of first filing. The last one, copy and modify. This is again very common. Please don't try to do that, because your patent application would be examined against everything that is out there. So everything that is there in the published form, electronically accessible, searchable. So your patent application would be again examined against that. It can include patent or non-patent literature. Please don't try to copy or modify something that already exists and try to file a patent application. So why to file patents? So you should have a patent strategy as a startup or an entrepreneur. This is very, very important, having a patent strategy. So it can be defensive, offensive, or commercial. Defensive is to protect your own idea or protect your own solution. Offensive is to sue others, and commercial is for licensing. So to briefly give you examples, I think defensive is self-explanatory. You're trying to protect your own invention. I don't have to give any example for that. Offensive is suing. So this has happened with one of my client. So one of my client, we filed a patent application for them, and subsequently the client and went and made a customer presentation. So customer rejected the solution and built something identical and started marketing within 1 month from the demo. Now the customer did not know that there was a patent application that was filed. So my client reached out to me and sought my advice as to what would be the next step. So since we had already filed for the application, we had taken the preventive measures and the disclosure was made. So the disclosure or the presentation to the customer was made under an NDA. Uh, the client had all the proof about it, all information about it. So we initiated a litigation against the customer. So this is a classic example of an offensive approach. Commercial is through licensing. So there are enough examples. You can Google up Qualcomm licenses its patents. 70% of their revenue every year is generated only through patent licenses. Their revenue per quarter through patent licensing is close to $1.2 billion. It's not per year, per quarter. So you can multiply that by 4, and that is the money that patent makes for Qualcomm. Likewise, you can also look up for this information. Microsoft, which has nothing to do in Android, has patents in Android, and they made close to $2 billion, I think, in 2018, only through licensing these Android patents. So you need not look at solving problems only in the domain in which you're working. IP is created once you start thinking and solving a problem. The IP may be generated, and it's always good to take steps to protect it. So again, why to file patents? Lifeline in the valley of death in innovation. Yes. So I think COVID is again a perfect example for this. We've all seen businesses go through shutdowns. Some of the businesses are suffering, going through a very tough time. So if you have an active IP portfolio, a patent portfolio, you can license it and try to make some money from it. So there you can Google up and again read. There have been instances where Motorola has done that in the recession of 2008. Nortel Networks has done that in the recession of 2008. That was again a valley of death during the recession. Nokia has done that. Many big companies do that. They have a very active patent strategy for filing the patents and also licensing them. So you should have a worldwide patent strategy. Don't restrict yourself. I understand that the costs are high, but the rewards are also higher. If you're ready to take the risk, you never know what rewards you can reap. So the world is your playground, and have a global strategy for filing patents. So some of the do's, please seek professional help. Try to do a global patent search done before filing the patent application. This is very important because your patent application would be examined against everything that is out there. Please lay emphasis on value and not on the cost. We'll talk about this as we move ahead further into the presentation. Try to have all your disclosures covered under non-disclosure agreements, whatever uh, which is you're trying to do to the customer, to the investor, or anyone else, try to sign NDAs. Do it right the first time. Like I said, you cannot go back and edit your patent application if it does not meet the criteria as defined by the laws, rules, acts defined by the Patent Act. You cannot get the patent granted. Plan, budget, and strategize. This is very important. This is something that most of the startups fail to do. The moment they get funding or the moment they start, they park their budget for recruitment or for marketing activities and expanding. I will not say don't do it, but have some percentage parked for uh, filing IP. So that is the strategy you need to actually include. So please have clarity on how you go about it, because once you lose the rights, you cannot do anything about it. So treat it like a child because it is your brainchild. So I would like to emphasize this because, if you go back to the basic definition of what intellectual property is nothing but creation of your mind. So it's your brain which is trying to develop a solution, try to protect the solution in the best possible way. Please do not cut corners. Treat it like your own child. When you have a decision to make, you place this in front of you. If it was your child, how would you treat it? Would you look at cost? Would you look at the cheapest school? Would you look at the cheapest doctor? Or would you look at getting value out of whatever you spend? So that should be the approach towards IP as well, because you're trying to protect your brainchild. Some of the don'ts, please don't have short-sightedness, cost versus price. Again, I understand, most of the startups have shoestring budgets when it comes to filing IP. But like I said, you need to plan and strategize, and don't make a decision just based on the cost, because if the patent application is not well written, the price that you will pay later on is losing the rights. Let's say in the long run, you may end up saving a few thousands of rupees or maybe lakhs of rupees. But if you are not able to license the patent, don't feel that, just because the patent is granted, you are sitting on a gold mine. That is not true. You can only reap benefits if it has value, if you can derive value out of it. So please don't make a decision based on cost. Don't publish in journals, blogs, or publicly disclose, or try to post some post information about your idea in some a public forum like LinkedIn or Facebook or Instagram, and try to take people's opinion, because the probability of you losing the rights over your IP are very high. Don't Google. When it comes to IP, please do not Google. Try to seek professional help, because there are a lot of conflicting information that is out there. So it will only confuse you more. Don't do it yourself. Needs practice. Just to give you an example of why it is advised not to do it yourself. So Indian Patent Act has 160 sections and 140 rules. Likewise, the US has 390 laws and 1071 rules. So when you file an application, your patent application, every section of your patent application, which is be it title, be it abstract, be it claims define the scope and boundary of your invention, the detailed description, the drawings, the brief description of the drawings. Every section of your patent application would be examined against a subsection of Act, which are from 160 sections, and a subsection of rules, which are from 140 rules when you file it in India. And likewise, when you file it in the US, it is examined against a subset of 390 laws and a subset of 1071 rules. So unless you have the expertise, you cannot copy the jargon from the patent application and file it, because you will not know what to write. And Please don't treat the patent application like a blog article or a newspaper article or a journal article. You cannot just write stuff that comes to your mind and expect the patent to be granted, because your patent application would be examined against the sections, rules, and laws that are defined in specific act. So, I would like to conclude my presentation with a few takeaways. Some lessons must be experienced before they are understood. So this statement is made by Michael Batnick. Michael Batnick is a financial advisor. So likewise, I would like to reiterate this phrase. This is very much applicable in IP as well. Uh, if you cut corners on the cost, compromise, and file a frivolous application, you will end up losing the rights. So, and one other thing is, everything has a price, but not all prices appear on labels. This is very important, because many of them think that, uh, somebody is trying to provide a service at a lower cost, we should choose them over someone who is expert or someone who is charging more. Please do your diligence before you make a decision and decide, because the this thing, as it says on the slide, everything has a price, but not all prices appear on the labels. So you'll be able to relate to this only after 3 or 4 years, when you actually go through the process, and possibly, if you're lucky, you'll get the patent granted, and if you're not, if the job was not done properly, you may end up losing the rights. With that, I would like to conclude my presentation and open up the floor for questions. I am reachable on this number or on this email address. If you want any help with respect to any kind of IP, be it patents, trademarks, copyright, or legal compliance of open source software. We also do IP litigations, and we provide legal support to the startups as well with respect to their agreements and contracts. So I open up the floor for the questions.